Start with Bryan Keith Johnson against the state.
Good afternoon. My name is Stephen Seliger. I'm a lawyer in the Appellate Division of the Public Defender's Office of the Second Judicial Circuit, and I'm here on behalf of Mr. Johnson. If I could reserve 5 minutes for rebuttal, please. Although the parties spent some time writing in their briefs about probable cause and reasonable suspicion, this case is only about consent. The chronology is pretty straightforward in this case, and so I'll go over it. First, there is a legal detention of the car in which Mr. Johnson is a passenger. As the record shows, he had nothing to do with the stop. The police officer stopped the car because it had a tail light or something that was out or made an improper turn. The police officer conducts some identification checks, gives the driver a warning. At the conclusion of the traffic stop, Mr. Johnson and the driver are, at that point, constitutionally free to leave, although the police officer does not say anything to that effect. Instead, the officer tells the driver and Mr. Johnson, as the officer testified he does in every stop, he asks the driver, do you have anything on you or anything in this vehicle that's going to get anyone in trouble? The response from the driver and Mr. Johnson is no. Then the officer goes on and asks, do you mind if I check? The judge finds, as a matter of fact, at the hearing in this case, and it was a disputed issue of fact, that Mr. Johnson at that point does give consent to search his person. At that point, Mr. Johnson opens the passenger door to get out of the car. At that point, the officer tells him, get back in the car. The judge at this point makes a finding of fact that that command from the police officer constitutes an illegal detention. The police officer then goes, searches the driver, searches the car, then gets Mr. Johnson back out of the car and searches his person, and that's when they find the contraband, the illegal drugs. Here's how the judge framed the question at the motion to suppress hearing, and I think it's a fair way to do it. The judge says if consent is given during a consensual encounter, and then before the search is conducted, that encounter again becomes a detention, and it's an illegal detention. Does that illegal detention vitiate the consent, and does that eliminate the consent that the judge found was valid prior to the illegal detention? In answering this question, the judge he answers his question, no, that the illegal detention does not vitiate the consent. In making that conclusion, the judge essentially finds the subsequent illegal detention irrelevant to the legal analysis. We think that's wrong because the difference between consent and any other reason under the Fourth Amendment that a police officer has a right to search someone is consent can always be withdrawn. If a police officer has reasonable suspicion, then the police officer can frisk for weapons or the basis for that suspicion. Of course, if they have probable cause, they can arrest or search based on that probable cause. And there's no way the person who's the object of that search can say, I'm sorry, you can't do that to me. But when the Fourth Amendment basis for the search is consent, the person always has to have the opportunity to say, I'm changing my mind.
Well, he still had that opportunity, correct?
Well, not once the officer tells him.
So you're saying that the officer made the decision for him?
Yes.
In essence. And so even if he said, no, officer, I really want you to search me, I mean, would still have his authority have gone?
Well, that might be a different fact outcome, but we don't have those facts.
I wonder if the officer said, sir, I want you to stay in the car. Shouldn't have said that. And then he comes over and he says, sir, do you mind if I search you and ask him again? Would you say at that point it was okay?
I would say at that point it's okay because the judge even said that this is not a case.
So all you're really saying then is that the illegal detention was a withdrawal of consent.
As a matter of law.
As a matter of law, not as a matter of fact-finding. So the judge gets to look at the witnesses, gets to evaluate everything, doesn't matter. Once he told him to get back in the car, that was the officer withdrawing the voluntarily given consent.
That's our legal argument because, as a practical matter, the judge finds, as a matter of fact, that because of a clearly erroneous standard. We can't say that in his deciding that he believed the police officer as opposed to Mr. Johnson, that's clearly erroneous. But again, it doesn't matter, because once the detention occurs that's illegal prior to the search, that's the legal equivalent of Mr. Johnson withdrawing consent. That's our legal argument.
And do you have any authority for this argument?
I have to say no, Judge, and that's neither the judge said. This is a fairly unique circumstance. I mean, the cases that are cited in the brief, for our brief, talk exclusively about detention consent, and the judge recognized certainly that if there was an illegal detention and then subsequent consent, that almost always that consent is not voluntary. But well, this is a case.
The theory is there that the consent is presumed to be a product of the fruit of the poisonous tree, a product of the illegal detention.
That's right. That's exactly correct, Judge Benton. In this case, the factual difference is that the police officer gets the consent prior to the illegal detention, but doesn't conduct the search until after the illegal detention. In the cases that we generally talk about, what happens is the police officer conducts the illegal detention and then gets the consent to search, almost always clearly involuntary under that factual circumstance.
So just that statement, no timing, it really comes into play? I mean, obviously within reason, but I mean, because in the other cases where the consent was withdrawn without the defendant actually saying it, I mean, they jerk their hand away, they reach in their pocket, they do something that would make a reasonable person think, I don't want you to do this anymore. And here, just the officers stay in the car is
And the reasoning behind that, Judge Hawks, is because once you have a search based on consent, the cop cannot then command you to do something to effectuate that search because it's voluntary. So anything the cop does that takes it out of the realm of your choice, that makes it involuntary. And when there are cases, Judge Hawks, that talk about when a person gives consent and they're in a vehicle and they get out, and even when they run away, that is the withdrawal of consent.
Well, with running away, I mean, it does seem like they don't want you to go through their pockets anymore.
Exactly.
But didn't he testify here that he was trying to get out of the car in order to comply with the request for the search?
The search of the car, Judge Benton, not the search of him. That's the critical distinction in this case. His testimony was, which the judge didn't accept, and we recognize that the police officer never asked him for consent to search. The judge found to the contrary. But the evidence was uncontroverted that the reason he got out of the car was so that in compliance with the driver's consent to search the vehicle, he was going to help that. So that's why he gets out of the car. That's what he testified to. It wasn't in any way related. You can't take his testimony to back up the story that was to help the police officer search him, because his testimony was that in his mind, the driver had said it's okay to search the car, and at that point, Mr. Johnson had no control over that. He couldn't do anything about that.
So, I mean, on all these other cases, we really look at what would a reasonable person think. So here, you know, the fact that the officer didn't realize that his command was in improper detention doesn't save him. And I suppose that if the officer thought that he was giving an invalid detention, you know, an illegal detention for whatever reason, he decided, he makes his decision, I'm going to illegally detain this individual, but in fact, when we look at it later, it was not an illegal detention, then the consent would have been valid even though the officer thought that he was doing something illegal, but it turns out later he wasn't, then the consent would still be valid?
So are you analyzing this from the police officer's perspective?
Well, I'm saying that if the police officer, you know, same set of facts, except the police officer, instead of believing that I'm changing two things. One, the officer now believes that he has illegally detained the defendant for one reason or another.
When he gives the command to get back in the car.
You know, and,
okay.
and in reality, it wasn't illegal detention. It was okay. But the search continues. So now the officer thinks he did something to detain him, and that should destroy the consent, but you're saying it wouldn't because it wasn't an illegal detention. I mean, what we're doing on the consent is we talk about knowing and voluntary, and now we're taking it away from both of the actors, and we're putting it in to be heard at a hearing months down the road.
Well, what you're doing is you're taking a circumstance where you're changing, which often happens, and this is not an unusual circumstance, where a consensual encounter morphs into a reasonable suspicion encounter. I mean, or a probable cause encounter. It happens all the time. That's what we're saying. We're saying is this is the equivalent of a consensual encounter that transforms itself into a detention encounter, at which point he had to have reasonable suspicion, and he did not, because the only basis to search him, and the search took place after the illegal command to get back in the car, was consent. And I'm into my rebuttal time, so
Counsel,
I want to say
I'd have one short question. Either now or in your rebuttal, I'd like you to address the cases cited by the state, which they say stand for the principle that once the consent was given, the occupants may be detained to ensure an orderly search of the vehicle.
Okay, and if you don't mind, I'll save that for rebuttal, but let me answer it briefly now. Both those cases, and I want to say it's Cromartie
and May.
Both those cases, remember, deal with the search of the car, not the person. That's a really important distinction. So the police officer can control the people for purposes of searching the car.
And isn't that why the police officer asked the appellant to return to the car?
No, not to search the car, because I assume the police officer asked him because, although there are two other police officers there, and I don't know what they're doing, there's no evidence in the record what they're doing, but he asked them because he wants to be able to control him inside the car. That's what he says. Mr. Johnson's not free to leave at that point, according to the police officer. He's got to get back in the car. So that really is the critical factual distinction between those cases and our position here. But if you want, I'll be glad to talk more about that. And I'll tell you, those are their best cases.
May it please the Court, Philip Edwards on behalf of the state. The touchstone in Fourth Amendment analysis is reasonableness. And in this case, I think what we're really focusing on is whether or not the detention that occurred after the consent, whether that vitiated the consent. And I would submit that it did not. It was actually a legal detention, because the cases that I did cite in my brief that talk about when there is a consent to search a vehicle, that the occupants of the vehicle may be detained pending the outcome of that search. And that's done for orderly purposes, for safety, for in case there's contraband found. There's good, reasonable reasons why that happens.
So you're saying that we should affirm the judge and basically say, okay, Judge, you were wrong when you said it was an illegal detention. Since it was a legal detention, the consent was never lost, and we're going to affirm.
I believe that would be a correct analysis. And I'd also like to just say one more thing about that. I think that when a person consents to be searched, it's implicit that they are consenting to be detained temporarily pending the outcome of that search. And if they don't do something that indicates that they're revoking that consent, then there's no reason why the officer would believe that they have revoked that consent.
But if does it ever get to the point, I mean, what did this officer weigh, 385 pounds or something?
285.
285, and he's
Yes.
6 foot.
6'3".
And, I mean, does it ever get to a point where maybe the defendant just doesn't quite have the courage to say no?
Well, that's possible. I mean, you have to take all factors into consideration, and I think we have to defer to the trial court here.
But he said an illegal detention, so now he's illegally detained. He's stuck in the car. This big old officer, 2 more show up at the back of the car. You know, I mean.
Well, I think the trial court found that he was illegally detained, not because he gave into authority. It was just because that the officer didn't have the authority to detain him at that point. And I think the trial court was wrong on that point, because I think that he did have the right to detain him pending the outcome of all these 3 searches that were consented to. So we had a situation where we had a consent to search the vehicle, a consent to search the person of the driver, and a consent to search the person of the passenger. So we've got 3 searches here to conduct. and it had to be done in an orderly, safe fashion. So I think it was reasonable here. First, take out the driver who's in command of the car. The officer testified that's why he said, sit tight. You know, the appellant it's undisputed, was getting out to facilitate the search of the vehicle. He, assumed rightly that you need to get out of a car if it's going to be searched. But they wanted to search the driver first. He was in control of the vehicle. You search the driver. You make sure that there's no contraband, make sure there's no weapons on the driver, then have him stay towards the back, and then you can search the appellant to make sure he had no weapons, and then you can search the car. It's a reasonable, orderly process that occurred, and contraband was found on the appellant. And I think that, the touchstone is reasonable, so I don't think there was anything unreasonable here. And I don't think that it was an illegal detention, because I think for all the reasons I just mentioned, that it was a legal detention.
But if it were a legal detention, that might obviously...
It was not to facilitate the search of the car, because he was trying to facilitate the search of the car himself by getting out.
Right. It was to facilitate all three searches, basically. He wanted to search the person of the driver first. And I cited the case...
You're saying if the driver consents to a search of his person,
right,
the authorities may order the detention of anybody else in the car.
The Breed case says that, yes. The Breed case from the 5th District in 2005 that I cited in my brief says either the vehicle or a person, and that's just, for safety reasons, for orderly, so that you don't have people just walking about.
Is that because he's detained because the vehicle is stopped? Could the defendant have decided he just wants to walk home?
He could have.
You consent to this stuff all night, buddy? I'm just going to go home?
He could have done that, and the officer testified if he would have known that the appellant was revoking his consent, he would have been free to go. But he did not. He just assumed, because there had been nothing to revoke that consent, that he was just trying. Everyone realized that he was trying to get out to facilitate the search process, not to revoke his consent.
Doesn't that mitigate for consent? If he's trying to help, and, here, let me get out, that'll help you even more, and let me empty my pockets, that'll help you more. And
does that militate against consent?
No, mitigate in favor of consent.
Yes.
That he was.
Yes. I don't think there was any revocation of consent here in this case. I believe.
But now you are, of course, aware of these cases that say that if consent occurs after an illegal detention,
right,
then the presumption is that
that's true.
It is ineffective.
Right, and I would say, like I just mentioned a few minutes ago, the key difference is because when someone does consent to be searched, they are implicitly consenting to be detained temporarily, and so you're consenting to that. But when you've already been illegally detained, we don't know you didn't consent to that. You never consented to be illegally detained. And so that does taint your later consent. That seems logical to me, a logical distinguishment between those situations.
All right, so if we agreed with the trial judge that the detention was unlawful, isn't it true that what then transpired was a decision not to withdraw consent?
As a matter of law, as the appellant was...
Well, you would agree with the basic proposition that counsel for the defense advances here, that consent can be withdrawn at any time.
Correct. Absolutely.
All right, so one thing that happened here is that after the detention, which the trial judge found to be illegal, the citizen did not withdraw his consent. And so I'm asking you logically, why is that not tainted just as an original consent would be tainted by the same illegality?
Well, that does have some logic to it, I'll admit. I would submit that it was a legal detention here. There's just not very many cases dealing with that. It's something that courts will have to grapple with. There's some logic to that. But, in this case, I would say that we did not have an illegal detention.
So is it your argument that the only way we confirm the trial judge is if we find that the detention was legal?
I would say that you should find that way. I can't say that that's the only way. it's possible that you could
then
still.
Since you found so much logic in Judge Benton's question, then there would come a point in your analysis that eventually the police officer could engage in so many illegal activities that eventually we would have to assume that under those circumstances, the defendant would have withdrawn his consent, even if he didn't
Right.
consent.
The touchstone is reasonable. That's why it's hard to make bright lines. And the United States Supreme Court has said time and time again, we're not going to make bright line rules most of the time in this Fourth Amendment analysis because it depends on each case, and it's a fact-intensive situation. So that's why it's hard for me to say what would happen in any particular case.
Well, what if he had cocaine in his pocket and marijuana in his sock? Why do you think he did not withdraw his consent?
Well, Your Honor, I've been practicing law long enough to just wonder, this is a very common thing. People agree to be searched and they have contraband, and I can't answer why that happens.
Well, maybe he consented thinking he would be able to get out of the car and dispose of these things.
Out of his sock.
And then when it was clear that he was not able to, how do we know that he would not have withdrawn his consent but for the illegal detention?
Well, I think this is a lot of conjecture. I mean, we know that he was trying to facilitate the search of the vehicle. He said he never consented to the search. The officer testified differently. The judge believed the officer. So it's hard to say, with all these different scenarios, if he could have later on, revoked his consent if this somehow. I submit under the facts we have here, he did not revoke his consent to be searched, and this court should affirm. Thank you.
Thank you, Mr. Edwards.
Judge Nortwick, did I answer your question the first time? The thing about Cromartie is that, again, it's the police officer getting consent to search the vehicle. So under those facts, the police officer can make everybody sit in the car. No one's getting out and he's ordering them back in. He's getting permission to get them to stay in the car. I mean, he's commanding them to stay in the car. The important other distinction about Cromartie is, and this is pre-Brenlin versus California, is that Cromartie says one reason that's okay is because the passenger has no standing to challenge the stop, the search of the vehicle. Well, of course, that's not true anymore. So Cromartie's wrong on the law about that. But again, on the facts, those cases are distinguishable because it deals with the police officer asking, can we search the vehicle? It has nothing to do with searching the individual. And this is the case where it's the police officer asking to search the individual, and that's the critical factor.
What about the fifth DCA Breed case, which seems to say, or does say, that if once the request to search the vehicle or the person is granted, then the officers can detain all of the occupants of the vehicle until the search is completed?
Well, and again, remember the facts of that case, if I have this right. They were searching an RV or something, and so it took them like 2 or 3 hours to do that. And so the big dispute was how long do the police have to search a vehicle? It had nothing to do with the people. It had to do with they were there for 2 or 3 hours searching this really big RV, and ultimately after they take it apart, they find drugs in it. I think it was an agricultural stop. But that's, again, I understand the languages in there, Judge Norton, and like I said, those are probably the state's best cases. But the facts of those cases are critically different because they don't specifically deal with the search of the person.
Would you believe that? Would you agree that if we found that the detention was not illegal,
that's the end of the case? I mean, the only weird thing about this case is the judge finding detention ends after the stop of the car. The cop consensually asks, can I search? Mr. Johnson says yes, and the judge finds that's consent. But then the police officer engages in activity that the judge finds is illegal as a detention. So that's the distinction, because I don't think we'd be here if the chain of events was everything that the police officer did was legal. Thank you.
Thank you, Mr. Seliger.